So I'm Terry Fisher. I teach intellectual property at Harvard Law School, and I'm the faculty director of the Berkman Center on Internet and Society. I was asked to talk here about the economics of the music industry. I'm going to treat that invitation as encompassing a little bit of the film industry. As it happens, not sure whether this was intentional or not, that what I have to say dovetails quite nicely with this very interesting presentation you just heard. The Convergence culture actually figures in what I have to say. Now, the thesis of my talk is going to be that we are at a point of choice or inflection with respect to one sector of the entertainment industry, at least for the time being, the sector that includes recorded music and film. A choice point, a moment of inflection in which we have to choose among alternative paths. And those paths are, first and foremost, legal in character. There are fiercely contested major issues involving the legal foundation for the entertainment industry, and which of the major roads we pick will have a big impact on the economics of the field and on the culture of the field. So I'm going to say a few words at the outset about the... This is the point where you say, get a Mac, right? About the past. On the assumption that most of the aspects of the history, of the recent history of music and film are familiar to most of you here, and devote the bulk of my time to sketching these three alternative trajectories for the future. So, first point about the past. The music industry, and to a lesser extent the film industry, are small economically. Compared to, say, consumer electronics, they're tiny. But they're enormous culturally. Department of Commerce statistics suggest that the average American adult watches approximately 3,000 hours per year of recorded entertainment, video and audio. That's 8 hours a day, 365 days a year. You might say, well, how's that possible? It's because people watch or listen to entertainment a lot in the evening, and then they multitask a lot during the day. The numbers are not quite so high in other cultures in the world, but they're high, and suggests how deeply these materials penetrate our daily lives. The consumption, comparable data on the consumption of magazines and books are, at least in the United States, going down. The consumption figures for games, connect to our discussion just in the preceding session, are going up. All right, that's the first observation. Second observation is that the legal foundation for this system is intricate. So, here's a quick review of the major relationships among the players in the music industry at the start of the technological revolution of the last 15 years. Composers, in the typical case in the United States, assign their creations to publishers who market their wares in a variety of channels, including sheet music printers, foreign sub-publishers, movie studios, and through the Harry Fox agency, most importantly, record companies. Those are reproduction and distribution rights. And then public performance rights are distributed through ASCAP, BMI, and CSAC, collective rights organizations, which issue blanket licenses to radio and television stations and restaurants. Two sets of creators in this regime, the composers at the top and the recording artists in the bottom, and their works, their copyrights, are pooled by the organizations at the bottom of the page here. Money flows through the system backwards through the channels cut by these legal rights, so upward like this, with one exception. About $100 million a year goes crosswise here. All right. It's an intricate legal structure that has, upon which has developed an intricate set of licenses, business models. This traditional business structure had, still pre-technological revolution, some very important advantages. Most importantly, it sustained an enormous and increasing output of material. As American popular culture, generated in this fashion, swept the globe. It had some demerits, some flaws, that alone surely would not have resulted in any major change, but are worth noting. And those demerits are high transaction costs, inequality in distribution. This is the distributive justice aspect of what in the preceding presentation was referred to as the long tail phenomenon. Increasingly over the course of the 20th century, a smaller and smaller set of people earned larger and larger shares of the revenues in the music and, to a lesser extent, the film industry. And finally, homogeneity of content, a convergence. So of the both music and film industry. In the last 30 years, before 1990, the number of albums released each year, or the album equivalents released each year, shrank. And the number of major film releases was stable, even while the total amount of money spent on each of those fields was going up. So more and more homogeneous output. Those characteristics of the traditional entertainment industry were destabilized not by internal pressure, but by technology. And the principal technologies, again, moving fast through stuff that's undoubtedly familiar to most of you, are digital recording and storage system, compression and decompression systems, and most importantly, the communicative power of the internet. Those technologies together have sustained the rapid spread of downloading, interactive, and non-interactive streaming as mechanisms of gaining access to recorded entertainment. These changes have huge economic benefits, economic and cultural benefits, and also equally prominent and nearly as famous hazards or dangers associated with them. The advantages include large cost savings. Roughly speaking, the details on this I'd be happy to go into if you're interested in the question and answer period. Roughly speaking, half to two-thirds of the cost, the retail cost of a CD, can be saved through internet distribution. They're not yet saved by the business models that are emerging in this field, but they are potentially savable. Cost savings. Second of the advantages of this technological shift is elimination of under and overproduction of materials, convenience and precision in what you gain access to, a rapid increase in the number of musicians who can reach and make a living from niche audiences, much greater diversity in the cultural materials that we, as a result, gain access to. And last but not least, here, just to incorporate by reference the discussion in the preceding hour, at least lawyer academics term for the phenomenon of cultural convergence and the rise of the amateur, which figured so prominently in the last talk, is semiotic democracy, redistribution into the public at large of the capacity of making cultural meanings. Okay, those are the advantages of this dramatic technological change of the last 15 years. There are also, correspondingly, hazards, dangers, which have driven the legal controversy and continue to power us toward the choice point in the roads in the future. So those hazards are first and foremost threats to the traditional business model I sketched a minute ago, and a corresponding diminution, the causes of which are hotly contested, but overall, uncontroversially, diminution in the revenues earned by the principal suppliers of recorded entertainment. So here's some data on this score. This is global and domestic peer-to-peer usage as of June of last year the time the Grokster decision was decided. You might think they would drop after the Supreme Court tightened somewhat the rules of third-party liability. Well, they turn out not to have done so. So peer-to-peer traffic continues, and there is some causal connection between that and these. The trends in retail sales of recorded music peaked in units in 1999 and slid then for 4 years thereafter. Same slide is observed in the value generated, retail value. There was a blip, or what in retrospect turns out to have been probably a blip upward in 2004, but the most recent figures from 2005 suggest 7 to 8% decline again. Globally, you see more or less the same thing. Though we don't have 2005 figures out, this is the same trend at the international level. Okay, that's the famous and most influential of the hazards associated with the new technologies, but there are two others worth mentioning. They're of special concern in Europe right now. Threats to moral rights. This, again, connects with the very interesting discussion we had in the preceding hour. The malleability of the materials that end up in the hands of consumers afford them semiotic democracy, but for exactly the same reasons threaten the artist's interest in the integrity of their works, prompting a growing set of legal challenges. The same tendency of consumers to seize upon and remake the materials that come into their hands will, over time, threaten stable cultural reference points. This issue was raised, I think, interestingly, in the very last question in the preceding talk, the issue of what's the relationship between centralized production, mass production of culture, and decentralized folk culture. Well, the more the second swamps the first, the less and less stable will be the cultural reference points that we all use for resources. Resources for parody, resources for play, resources for self-definition. All right, so what I've done very quickly thus far is sketch the traditional business models in the music industry, the ways in which technology has destabilized those, offering us simultaneously huge potential economic and cultural benefits, and on the other hand, very large dangers or hazards. The dangers or hazards have provoked, over the last 15 years, a war in which there have been cycles of innovation and resistance. In each of these settings, a company, typically, sometimes several companies, have developed a new mechanism for delivering recorded entertainment to consumers, which offers to the consumers substantial benefits in terms of convenience and flexibility, but also destabilizes the traditional business model. And the organizations disadvantaged by that have fought back, sometimes fought back in litigation based upon existing copyright law, sometimes have fought back through law reform, and sometimes have fought back through technology. In each of these contexts thus far, from digital recorders to improved PVRs, that TiVoization, the extreme TiVoization of replay TV, the copyright owners, the holders of the entitlements disadvantaged by the technological innovation, have as a legal matter won. The most recent example of that was the Grokster decision. But in each case, to repeat, the copyright owners have prevailed, but have not stopped the continued flow of new destabilizing innovations. Okay, so against that backdrop, looking forward, where are we going? Where could we go? So, repeat, my suggestion is there are three roads we might pursue here. You can imagine intermediate positions, but I think it's easiest to see this analytically as three distinct paths. The first one is we could imagine leaving the legal system in place. There have been cries previously for legal responses to technological disruption. The most famous of those was the effort of the film industry to secure modification of copyright law to reduce the threat associated with the emergence of the VCR. that was turned aside, barely, in the 1984 Sony Betamax case. Analogously, we could imagine here, responding to the pressure for modification of the legal regime governing the current entertainment industry, saying, no, hold it more or less constant. What would happen if we took this approach? Well, we can make reasonably good guesses by just extrapolating from what's already happening. What has happened in the last year? We've seen the emergence of a very promising, interesting, still small scale but rapidly growing set of new business models. They include online stores, of which by far the most famous is iTunes, growing quickly. But there are 230 others out there which may begin to cut into the market share of Apple. MovieLink is just beginning to offer a la carte analogous delivery in the film context. Online subscription services like the new Napster or Stars. Authorized peer-to-peer systems, some of them building upon the technology of Sean Fanning's new company, Snowcap. Each one of these uses the existing legal system to deploy material without enhanced legal or technological shields in hopes of making money. Where are things going in the future? Well, the relevant consulting houses have somewhat different predictions. The most optimistic by far is Forrester Research. Gartner G2 is the blue zone here. If you take that as the intermediate model, we're still in the zone of projection by 2008 of $1 billion. That's not on the scale of the music industry. In its current form, we're now at about $10 billion of retail outlets in the domestic music industry, but it's not trivial either. So, a crucial question in both guessing the trajectory here and evaluating it, is this something we want or not, is this. How do these things compete with free? If, as we've seen, unauthorized, not-for-fee, peer-to-peer systems are continuing to dominate the world stage, how do people make money using these new business models? There seem to be 4 explanations in combination explain the emergence of these new systems. The first is they appeal to customers who fear infringement suits. Those numbers are still relatively small, but growing. Second answer is that the courts in the United States and increasingly in other countries are gradually, very gradually, clarifying the standards for third-party liability and increasing the vulnerability of organizations that make money from offering unauthorized services. And the Grokster, the collapse of Grokster after the most recent Supreme Court opinion is the clearest example here. Third explanation is that gradually consumers are becoming more aware of copyright, and at least a portion of them, 27% in the most recent Pew study, care what the copyright entitlements they are violating are. And last, and by no means least, the success of these enterprises against the backdrop still of the widespread availability of free models is basically a matter of convenience, reliability, and low cost. Okay, so that's the first path we might pursue and what would likely happen if we pursued it. Hold the legal system stable and expect to see the emergence and the gradual growth of some new business models. Are they capable of displacing altogether the old ones? Not so clear. Now, there's one issue here I'm going to bypass for the moment and return to right at the end of the talk. Just flag it for the time being. Under this heading is under the same general path. Preserve the existing legal system is an innovation we're currently trying at the Berkman Center. All right, the second path, more likely as a trajectory, certainly in the United States, a little less clear in Europe and Asia, would involve acquiescing in the demands of content owners for a reinforcement or strengthening of the property rights of creators. So these changes would come strictly speaking, in two different fields. First, changing copyright law along the following dimensions. Adding in the United States what already exists in most other countries in the world, a full public performance rights for sound recordings. Only a vestige of that currently exists in the United States. Eliminating the compulsory licenses that currently qualify copyright owners' entitlements in the United States and many other jurisdictions. Increasing criminal sanctions by lowering willfulness requirements and increasing enforcement of already existing criminal copyright penalties, not relying just on civil suits, but people go to jail. Streamlining the civil enforcement systems in a manner that two scholars have already proposed. And last but not least, expanding third-party liability on a statutory basis so as to increase the pressure upon groups that enable consumers to violate the copyright statute. All right, those are all likely changes in copyright law, both domestically and internationally. Paralleling those, seen as supplementary in the minds of advocates for this course, are legal reforms that would reinforce the self-help strategies employed by the major firms. Those include strengthening anti-circumvention rules. In the United States, those are reasonably stable now in the form of the Digital Millennium Copyright Act, but in Europe, they're gradually spreading in conformity with the EC Copyright Directive on this issue. Liberalizing rules governing spoofing and interdiction, increasing the authority, the legal right, of copyright owners to deliberately contaminate the internet in order to disrupt the exchange of free materials. The Consumer Broadband and Digital Television Promotion Act, the most recent name for an initiative currently on the back burner but enthusiastically offered by Disney and likely to be offered again, that would require the manufacturers of all consumer electronic equipment to embed in their devices hardware that recognizes and enforces signals, tags set by the copyright owners. Reinforcing the broadcast flag rules, reinstating the broadcast flag rules recently struck down by the FCC on jurisdictional grounds, and plugging the corresponding analog hole that weakens those. All right, those are all systems that would reinforce the ability of copyright owners to engage in self-help, meaning wrap their products in technological shields that not just mimic but exceed the legal rights they obtain under copyright law. Okay, so that's route number 2. What happens if we go down this route? Well, some good things and some bad things. So, most likely, if the legal system is adjusted in this fashion, media companies, the current holders of the major copyrights in this field, confident in their ability to make money in the new internet environment, would accelerate their usage of systems like iTunes and their ilk. You would see, with the clarification and reinforcement of property rights in this context, the emergence of more private licensing societies, analogous to ASCAP, to overcome the transaction costs that currently gum up the system. You would likely see, here's a good thing, musicians and filmmakers increasingly break free of their recording company contracts, because in this environment they would now have an effective way of making their wares available to consumers directly and earning money from them, which they currently do not. And last but not least, you would see in this environment a rapid increase, we will see in this new environment, a rapid increase in price discrimination. Price discrimination is the term economists use to describe a circumstance in which a good or service is offered to consumers of different sorts at different prices, or different versions of a good are offered to consumers at prices whose divergence is greater than can be explained on the basis of cost differences. So, practiced widely by airlines, practiced occasionally in the entertainment industry in the windowing system, corroding in the entertainment industry, as we've most recently seen the deterioration of the windowing system under the pressure of peer-to-peer distribution. Price discrimination in this altered legal environment would rapidly increase. it's a peculiarity from the standpoint of the business that CDs are all more or less the same. Costs $18 retail in the United States, something comparable in most other jurisdictions. The same price for music of lots of different sorts, and the same price to different consumers, even though their ability and willingness to pay varies a lot. The capacity to prevent the recirculation, the arbitrage of the products generated by the entertainment industry would unleash the capacity of the firms to differentiate among consumers and how much they paid for artifacts. So, huge increase in price discrimination. Disadvantages of going down this road include the following. The major record companies and studios may appropriate the savings. That is one of the principal benefits of the new technologies. The price signals sent to creators would continue to be distorted by the fact that objects are being sold rather than counting the frequency with which people consume them. So an imperfection in the current market would continue. Technological innovation would slow. So examples of technologies that would be endangered by the adjustments in the legal rules just sketched would include iPods, TiVo, CD burners, and so forth. Critical and transformative use of recordings would be curtailed. So semiotic democracy, the phenomenon, the rise of the amateurs discussed in the preceding session would be limited in this new environment. The end-to-end principle on which the internet has been based would be undermined. Price discrimination, in some people's judgment, of the sort I just sketched, would be culturally corrosive. And last but not least, this legal change would be imperfect in its effects. You would continue to see struggle, a black market in entertainment products analogous to the war on drugs. Okay, so that's a suggestion of the advantages and the disadvantages of road number 2. It is, at least in the United States, the most likely of the roads we pursue. The third and last of the approaches would contemplate replacing the current copyright system with an alternative compensation system, a different mechanism for pursuing the goal of fairly compensating creators without whose contributions none of this would be possible, while simultaneously harnessing the economic and cultural advantages of the new technologies. The theory that underlies this proposal is that the current copyright system is only one of 5 possible responses to the hazard that intellectual products, entertainment products in particular, will be underproduced in the absence of governmental intervention. Since the 17th, maybe 18th century, we have relied upon this strategy to induce the creation of cultural products. Namely, we grant producers thereof protection against competition in the manufacture and distribution of their copies. The increasing deterioration of this strategy suggests we rethink it and choose one of the other 5 approaches to generating incentives for the creation of intellectual products, and this one in particular, a prize system. So how would this work in the entertainment industry? Well, the basic layout here. For the details, I'd be happy to respond in the question and answer period or outlined in the last chapter of my recent book. The basic components of such an alternative compensation system are as follows. The creator of a recording, the copyright owner of a recording, would register it with a government agency, most naturally in the United States, the Copyright Office. Money necessary to compensate those creators would be raised not through purchases of products, purchases of copies, but through taxation. Ideally, economically efficiently, through income taxation, but given the impediments to adoption of increases in income taxes, more plausibly through a tax on the devices and services used to gain access to recorded entertainment. A great deal of my recent book tries to figure out what exactly are the numbers here. How much money would one need? And the bottom line is approximately $5 a month per household in order to fully offset the diminution in the revenues in both the music and the film industry as a result of the legalization of online distribution of digital recordings. That number would go up over time, but would always remain substantially less than the amount of money American households and world households are currently spending for purchases of recorded entertainment. This pot of money would then be distributed to creators in proportion to the frequency with which consumers gained access to their works, estimated through a sampling system that counts not just the number of copies made, but the number of times each copy is watched or listened to. Once such an alternative compensation system were in place, you would dispense with the aspects of the existing copyright system that are no longer working effectively. The advantages of this system would be considerable, but it also has, like any of these roads, some disadvantages. The advantages for consumers would be very large cost savings, unlimited access to entertainment. So this corresponds to what I gather is the central theme of this conference, namely, this would make possible open distribution of unencrypted entertainment products, not in the sense that consumers get them for free. They wouldn't. They would be paying for them through taxes, but open, free in the sense of unlimited access to unencrypted versions in unlimited amounts. The advantages for artists of this regime is they would get a reliable source of income and the opportunity to distribute their work directly to consumers rather than relying upon major intermediaries. The suppliers of devices and services upon which the taxes are levied would initially be hurt by the taxes, but the advantages of these new devices in the more rich entertainment environment would more than offset those. And the public at large finally would gain through decreased litigation and decreased lawbreaking. The social friction associated with path number 2 would be avoided. The disadvantages of this approach, however, are significant. The first is cross-subsidies. The set of people who pay for entertainment through this tax system would not be identical to the people who benefit from it, and that's economically disadvantageous and has some moral problems associated with it. Not all artists are going to be wildly enthusiastic about this approach in which malleable digital copies are readily available of all of their works. Anytime you locate this amount of discretionary power in a government agency, you run the risks of rent-seeking and capture, a serious danger, and yet unless and until the system were established globally, it would leak across national boundaries. Despite those problems, my argument is that this is the best of the 3 courses. In the United States, it's the least likely of the 3 to be pursued. In other jurisdictions, it's more promising. So as you may have seen, the French Parliament just recently rejected the recommendation of the ministry to go down road number 2 and tentatively adopted road number 3 as the strategy in France. Whether that will survive the second vote in the French Parliament and the pressure currently being brought to bear on the French government arguing accurately that their new initiative likely conflicts with the TRIPS agreement remains to be seen. Okay, so finally, I indicated that I would come back to path number 1 to address a last issue. Let's assume, plausibly, that an alternative compensation system established through legislation is not in the cards in the United States in the foreseeable future. Could we nevertheless create such a system or some components of a system of that sort without changing the law? And the answer is yes, you could, or at least we're trying to do so. So with some funding from the MacArthur Foundation, we're currently at the Berkman Center, attempting to create a pilot project, tentatively called the Digital Media Exchange, that would function as a non-profit, copyright-compliant co-op combination producer co-op and consumer co-op for the exchange of digital recordings. Digital recordings in a variety of media, first sound recordings and audiovisual works, but eventually a variety of other media as well. The suppliers for this stuff would include individual creators who would deposit their material in it, but would also, more importantly at the threshold, consist of intermediaries holding the copyrights in large collections of material, aggregators of content creators like the American Federation of Musicians, and conceivably also some of the artists associated with Creative Commons. And this is an issue maybe we can touch upon in the question and answer period, why it might be in their interest to partner up here. On the other side, the consumers who might participate in such a system would include, on the one hand, individual subscribers who would pay in subscription fees amounts of money approximating in the full-blown version the amount they otherwise would pay in taxes in a government-run system. And then aggregators. ISPs, already you see in England a pioneering move in this direction by one ISPs, and a very promising aggregator in the United States is universities, which have the capacity to pool the resources of their students, as well as the ability to levy fees upon them without their consent. This system would provide to consumers who participated in it at the basic level access to recordings in both downloadable form and streamed form, but also a variety of informational services, reviews, discussion boards, recommendation engines, and so forth that enable people to sift through the enormous pile of stuff coming to them. And a licensing service enabling people who wish to make commercial uses, not consumptive uses, but commercial uses of recordings found in the system to locate the copyright owners thereof and negotiate individual licenses. So this system would function in its mechanics more or less the same way as an alternative compensation system would on the governmental level, with one major exception. It would be run by a nonprofit corporation, which in turn is run by a council elected by the participating groups, as many co-ops already are. So the advantages of this system are similar to the advantages of an alternative compensation regime. The disadvantages, again, are similar, but there's one more worth emphasizing, the critical mass problem. One can, or at least an enthusiast like me for such a venture, imagine how it would function when fully operational. The problem is getting it going, is getting a significant number of suppliers to put their stuff in before you have a significant group of subscribers to offer them by way of a revenue stream, and conversely, getting a significant number of subscribers to sign up before you've lined up the suppliers. That's the main impediment to the launch of such a regime. The response is likely that such a system will be built in the first instance not upon popular mainstream material in the United States, but upon the enormous databases of already publicly available material in Brazil, foreign language material in the United States, China, and so forth. So we're actually going to China in March in hopes of assembling one of the major components of this start. Okay, so to review the business models in the entertainment industry, music most importantly, were reasonably stable as of 1990, were destabilized not by their internal flaws, which were modest, but by the advent of major technological innovations, above all, digital recording and storage systems, codecs, and the internet, producing a struggle, a legal struggle, a 15-year legal struggle involving 8 battles, each of which formally has been won thus far by copyright owners, but have failed in the process to halt the sequence of innovations. Looking forward, we can imagine 3 major paths. each of which dependent upon a fundamental choice as to the shape of our laws. Path number 1 is leave the legal system in place. Path number 2 is strengthen the rights of the current holders of copyrights. Path number 3 is to replace the copyright system vis-a-vis online distribution of recorded entertainment with an alternative compensation system. In the United States, path number 2 is the most likely to occur. In some other jurisdictions, maybe France, path number 3 is a possibility. Path number 1 is still possible here and holds out the possibility that in this shadow one could construct a voluntary co-op that would capture some, though not all, of the benefits of an alternative compensation model. Thanks very much.
We have some time for questions.
So variations of what you were talking about have been talked about on intellectual property blogs for a long time, and the way that they've been discussed, the naming has been compulsory licensing. And a lot of the arguments have been that under a system like that users who didn't consume media would be paying, whether they were paying through a tax on the device or some kind of tax through their ISP or whatever. And then the other problem being that people would game the system. And I'm kind of curious, you didn't go into those issues that much, and I'm wondering what your responses to those kinds of arguments would be.
Yeah. So, very good point. So the first, a terminological one. So you're right that proposals of this third source have been around for a while. In the legal environment, Neil Nathaniel has been writing about it, but Sandy Perlman is another person who has been enthusiastic on this front. I resist the term compulsory licenses because it's inaccurate in one important respect. A compulsory license is best exemplified in the music industry by the system under which the holders of copyrights in musical compositions have to issue, are obliged to issue licenses to the record companies for their compositions at a rate of, roughly speaking now, 8 cents per copy per song. That's a compulsory license in which they are compelled to license to some other person their copyrights for a fee paid back to them. It's in effect a price control on a traditional transaction between a copyright owner and a consumer. This is a different idea altogether, in which you replace transactions between the consumer and the copyright owner with an entirely different mechanism of funding. So it's in that respect that a compulsory license is misleading as a term. But with that qualification, you're right. They're basically the same proposals. Okay, so you mentioned 2 hazards, and you're entirely right about those 2 hazards. So they include, as I mentioned, cross-subsidies. This is the first of your 2 points. The risk here is that there's imperfect match between the people who pay and the people who benefit. Now, that can be mitigated with some fancy setting of the rate, so-called Ramsey pricing, in which you adjust the taxes so as to increase the taxes upon forms of technology where the elasticity of demand is higher, so that you cause less distortion of consumer behavior. So you can mitigate this problem, but you can't make it go away altogether. In that respect, this funding system would be analogous to, less severe in its distortions, but analogous to lots of other taxation systems. The easiest example familiar to Americans is real estate taxes for public school education. Huge disparity. Some people pay large real estate taxes and have no kids, get no benefit from it whatsoever. Other people have 5 children, relatively modest houses. They get big benefits and pay relatively small taxes. So it's ubiquitous in the tax system. This would preserve a medium amount of it. Another circumstance that I think softens the objection, but doesn't make it go away, is that the numbers I sketched, the details of which are in my book, indicate that even using quite conservative assumptions, under this regime, consumers per household would pay a little less than half of what they currently pay for access to entertainment. So the result is that even if some people are paying more than others, they'd have to pay a lot more than others to reach the levels that they are currently spending. Okay, so those are ways of mitigating the hazard, but by no means making it go away. That's your first objection and my partial responses to it. Now, the second is more tricky. As I suggested, to effectively run such a system, you need to estimate the relative popularity of different recordings. Now, for streaming, that's relatively easy. You just, in fact, the major streamers have already volunteered to provide playlists and the number of people signed on at a given time, and pay per listen systems are quite easy to track consumption. And to the extent that our primary mechanism of gaining access to entertainment rotates toward not having local copies of recordings, but instead receiving them delivered instantaneously, this is not problematic. But until we reach that point, as long as downloading remains a major way in which we gain access to entertainment, it is a hazard. And just as you say, the risk is ballot stuffing. It's in the interest of the holders of the copyrights in such a regime to exaggerate by, in the simplest scheme, downloading repeatedly to their own systems their own works. There's no perfect solution to this, but there are some possible ones, and they include sampling systems. They also include software that tries to balance, on the one hand, the hazard to privacy of tracking what individuals are listening to with detecting multiple repetitions of copyrighted materials. All right, here's one example of how this might occur. Each of the three major operating systems, Windows, Linux, and the OS X, actually has the capacity on a regular basis to check not only what programs, applications are currently in operation, but what files are being used in those applications. By requiring the aggregation of data concerning consumers' consumption patterns to observe not just the beginning of a play, but its conclusion, you eliminate one of the easiest forms of ballot stuffing, namely repeated starting and stopping of a recording. And with one other adjustment of the system, you could mitigate it further. And that adjustment is to establish a system analogous to the rule that currently exists in Section 114 of the American Copyright Statute. Namely, you only get credit for a certain number of plays of a given recording in a given time period. 1 or 2 or 3 per day, for example. That has a modest disadvantage on the other side, that if someone really does want to listen to Yellow Submarine 24 hours a day, it doesn't get fully counted, but it's designed to address the ballot stuffing issue. So the bottom line here is you are very accurately put your finger on two of the most serious challenges to an alternative compensation system: the cross-subsidies problem and the ballot stuffing problem. To each one of them, there are partial solutions. Neither, however, to neither of them is there a perfect answer.
Thanks. David Dawson from the Museums, Libraries and Archives Council in the UK. Just a couple of points. There's a couple of sort of models that occur to me immediately. The first is in the UK, there's the public library lending right, which some people will know, where the number of times a book is lent through a public library, a payment is made to the author, which is quite interesting because it occurs under the existing legal status quo. And second is the whole issue of the BBC license fee, which could be argued is perhaps an alternative compensation scheme in sort of starting to come into a slightly different way of operation, because there's a lot of discussion going on at the moment as to how the license fee could be used to fund public service broadcasting content, not just from the BBC, but also from other content providers, particularly as in the UK we move towards fully digital television and converged environment.
Yeah, so those are both, you're entirely right, two helpful, suggestive examples. The implementation of the first in the United States would require a legal change. The British rules vis-a-vis the public lending rate are different from those in the United States now. You'd have to modify what's known as the first sale doctrine here. But there are very good arguments that we'd be better to adopt the British model in the United States. Libraries are not going to be happy with this at the threshold, but from an overall social welfare standpoint, it's a sound point. As to the second, there are resemblances between the BBC model and an alternative compensation system, but there are also important differences. And the most important difference is that the choice of programming, as I understand it in the BBC system, has no bearing upon consumers' registration of what they want to watch. And the result is to increase resentment on the part of many consumers of paying that particular tax. Now, that may not be the only source of resentment, but it is one of them. But with those adjustments, I agree. Those are two quite suggestive systems.
Yeah. Manuel Raz from the Consumer Project on Technology. I have one comment and one question for you. One comment is that in France, they are, like you described, discussing what we call the licence globale, which is a compulsory license in French. So I understood to be a license. And the price of it was about 7 to 8 euros. I think it's going to be defeated next month, unfortunately, but it's interesting to see that you come up with a number like $5, you know. No, my question was more because, as you know, I work with Jimmy Love, and I was in Banff when there was a bunch of artists together proposing to try to fix this problem. And because all day long we talked about this new fusion between consumers and creators, or the blurring lines of who's a creator and who's a consumer, I think that it would be important to hear the voices of artists/consumers in what kind of a payment scheme they could live with. And that's why I was sort of amused to see it in red, because in Banff there were about, 50, 60 artists, not famous, not great artists, but artists nevertheless. I mean, like a lot of artists we talked about today. And their idea was there's a risk of creating the Britney Spears effect. And I would like you to comment on the Britney Spears effect, because it is bothering me, coming from a country where the government has been subsidizing art, and we do here too in some ways. There would be no opera if the government was not helping opera singers. But how do you fix the Britney effect in your scheme?
So, great questions. The Blurb Banff proposal as a mechanism for deciding how to distribute a pot of money is essentially to place in the hands of the participants in the enterprise as a whole the capacity to set the rules through voting. And you're entirely right, I gather, you were there, I was not, I just read the description of its output, that some of the participants suggested that voting might result in significant revenue streams going not to the producers of the most popular products, but to jazz musicians, to a pension fund for musicians whose careers are tailing off, to innovative new materials, flattening the distribution curve. Okay, so it's a very interesting proposal. My response is, I want to separate two things here. Is the reason why it's red, meaning in this portion of the chart, is because this portion of the chart is dealing with an alternative compensation system, a government-instituted system. And the hazards of placing into the hands of consumers, primarily, the capacity to vote as to the direction their money goes in is especially high from a political standpoint when the money is gathered without consent. That's the main reason why I'm skeptical of it as a component of an alternative compensation system in a government-run regime. By contrast, in an entertainment co-op, the voluntary analog to an alternative compensation regime, I think actually this proposal is quite wise and is a likely outcome of voting among the elected representatives of both suppliers and consumers. So my response to the merits of this approach have a lot to do with the degree of government involvement in it. Now, okay, so last point along this line. First, an observation. I'll bet Britney Spears was not at the Bullard-Banff proposal, so the musicians voting on this are not those who are the beneficiaries of this effect. So if it's widely available, this system is going to generate a conflict within the entertainment community. If we didn't rely upon voting to rechannel the excess, in some sense, monies that currently go to a very small portion of the producers, the Britney Spears, is there any other way in which the curve could be flattened? And the answer is yes. And this, again, returns to some of the discussion in the preceding hour. As long as we construct business models, and several of these would do it, that make it possible for artists to identify and serve niche communities and generate correspondingly a much richer array of materials available to consumers, and then supply consumers the search tools necessary to find the stuff they like, the flattening of the skew log normal distribution and the corresponding Britney effect is going to occur anyway, even without voting. So I don't think you need it, the voting system, but it does have some attractions, especially in the context of a voluntary rather than a compulsory model.
So you implicitly but not explicitly talked about the music industry itself, and then your chart of showing how money flows, there's at least one line missing from the music industry to the Congress of this country. So with that in mind, your path number 2 sounds like it might be optimum, given that, because what you said at least was that the filmmakers and musicians would have an alternate distribution mechanism, which is, I think, would make them interested in that path. If it also doesn't affect the music industry too badly, which you didn't talk about, it would seem to me an easy win.
Well, when you say an easy win, first let me make sure I understand. Your prediction is that the somewhat surprising but indisputable lobbying power of the entertainment industry. This connects to my very first point in the lecture, is the cultural and political power of the entertainment industry dwarfs its economic power. It's curious that. Okay, so your prediction is, taking that into account, we are likely to see this occurring. It's an easy win just taking into account the political economy here?
No, I'm saying what you said was that path would also enable musicians and filmmakers to have their own channel, to avoid the normal distribution channels.
Right.
So for them, it's a win also, if that's the way you talk about it. And as long as it doesn't impinge too badly on the normal industry, it would seem to me they too would be in favor of it. So therefore, you didn't comment what the effect would be on the musical industry.
So I tried to, but you're right, I wasn't clear enough on this. I don't mean to leave the impression that this is an unmitigated disaster. I actually don't think that's true. I think that it has some advantages and disadvantages. And you're rightly pointing out that it's not just a windfall for the four dominant record companies now and the corresponding film studios. It also has this big benefit here to musicians and gradually over time also to independent filmmakers. So you would see disintermediation in this environment. It will grow more slowly than on some of the other paths, but you would see disintermediation, which would redound to the benefit of the creators. Continuing this theme, the price discrimination that I talked about earlier has some advantages to it. It would have, among other things, egalitarianism. Price discrimination has among its benefits the fact that everybody gains access to entertainment. The rich pay a lot more for it than the poor, but that's one of the objectives of price discrimination, is charge what each sub-market will bear. And this arguably has progressive redistributive value. It's like progressive income tax embodied in the corner of the entertainment industry. So path number 2 has some problems associated with it, which I did mention, but you're right in reminding all of us that it's not a disaster. This is convergence in practice. And we're likely to find ourselves here.
Along the same lines, I'm a big fan of cooperatives. I always like to point out that approximately 1 out of every 2 Americans is a member of a cooperative today. Credit unions are cooperatives. People don't realize that. And the interesting thing is, along the same lines, is that even if Path 2 comes along, the digital media exchange is a very interesting possibility to coexist. Because cooperatives coexist along with banks, and 90% of all savings are in banks. But it turns out that almost as many people volunteer to work on boards of credit unions as are employed by banks. It's a massive sector in the society, and it is democratizing. The interest rates are lower. There's a tremendous amount of civic pride, democratic principles. All of the ideas that you outlined for their digital media exchange. I like to talk about information cooperatives, because we clearly need trusted intermediaries who might sell other kinds of services and become attractive. And so that there's no, in fact, it's more of a mixed sector, is that maybe we need to worry less about the war and more about building those kinds of alternatives, which will be peopled by, not by the Britney Spears of the world, they'll be peopled by all the folks who are closer to the folk culture as a means of expression, but maybe finding a way for a means of existence at a lower level of economic cost.
I largely agree with that. I'm a little bit nostalgic about and sure hope that in the second vote in France they actually try an alternative compensation system, but the likelihood certainly of it spreading to the United States is small. And so building a co-op here, which, just as you say, could survive in the current legal environment or survive in this tightened one, is much more promising for the immediate future.
Along those lines, and under the digital media exchange, when you were talking about the critical mass problem and the fact that it would be more likely to be populated with foreign texts, maybe that would be a very good thing because it would then reduce the colonizing function. That's happened. So, it would be another democratizing trend. I wonder if you could speak a little bit about that.
Yes, I also agree. It is rather extraordinary that in the entertainment markets in most countries of the world now are infused with American popular culture. Now, not alone. There's also a very vibrant Indian film industry, and there's a gradually growing African film industry. And so, but if you had to locate one dominant producer of popular culture, it's the United States, and my own view is it's pernicious, that. So to the extent that accidentally the structure of a digital media exchange would initially privilege everything but American popular culture, not so bad. Now, just to, in case you're curious about this, it's not just foreign language stuff that would likely populate it in the get-go. So we've actually been well down the road of discussions with aggregators of independent films and independent music who see in such a system the possibility of making significant amounts of money through the distribution of the pot that's collected for subscribers. But equally importantly, see it as a mechanism for just distributing their wares and relying upon ancillary sources of revenue at the threshold. So it's not just foreign language material, it's also basically, broadly speaking, independent material that we hope will be there at the beginning.
But I think in the previous session, there was a basic assumption that, well, one would be happy just playing with one's experiments at home, or else getting an audience on the internet, or getting into the industry. But there was the fourth alternative of really seeing an independent course that could in some ways challenge the dominance of the industry. I think that's a fourth, option that's very important.
Yep, I think that's exactly right. So besides agreeing, let me say one more thing about that, which is that it's implicit in all this, but I might as well make it explicit, which is there is in the talk of the wonders of open distribution sometimes some naivete about the need to actually compensate people who produce this stuff. And the aspiration of these sketches is to seize the cultural benefits of unimpeded, unencrypted distribution of copies, but also to locate revenue models. So to that extent, I'm in favor of free distribution in the sense that I gather Richard Stallman was here earlier to appropriate his terms, free speech, not free beer. Unimpeded distribution, but not necessarily costless stuff.
You mentioned briefly some of these hybrid peer-to-peer systems that have evolved, the peer impacts and the snow caps. Mm-hmm. Could you elaborate a little bit on that, on what the success of those chances are for those particular industries, do you think?
Well, SNOCAP's aspiration, they're the ones with the biggest aspirations here, is to provide a technology that in some respects actually resembles what I was describing with the alternative compensation system, in which basically you would count the flow through a peer-to-peer network of copyrighted works whose presence on the peer-to-peer system would be authorized, licensed. So that's what SNOCAP's trying to do right now, is negotiate licenses with the major first record companies so that they would permit the exchange on the authorized peer-to-peer system, then use the SNOCAP registration and tracking technology to count the flows of stuff through it and to collect from the subscribers money and distribute it to the copyright owners accordingly. So this is analogous to, in some respects, an alternative compensation or entertainment co-op model with one critical difference, namely it remains a la carte rather than smorgasbord in form, in which payments are made per unit rather than all you can eat. That at least is a current thought, but you can imagine it being compatible with a subscriber model as well. So here, this may be something implicit in your question, but if not, I'm going to draw it out. It's possible that these things, as they evolve, will become functionally a digital media exchange. In which case the need for a pilot system of the sort we're building, or trying to build, will dissipate. That the market may generate a structure like this. Snowcap could, without too many changes, become what I've sketched as a digital media exchange, in which case we would retire from the field.
I'm trying hard to see the benefits of the likely path too. In terms of price discrimination, do you really think it's plausible that there could be a sort of graduated consumption tax? Doesn't that presume a great deal of knowledge on the part of the recording industries and the film industry of our financial situations, and would it then necessitate a kind of IRS of the recording industries? I mean, they would be behaving a lot like the government, whereas now we have, piracy or whatever we call it aside, as sort of a flat tax of consumption.
So,
is that plausible?
Yeah, it's plausible. For better or worse, it's plausible. So, give you some suggestions of how it might happen. The key here is strong property rights, intellectual property rights. So we shut down through a combination of civil and criminal sanctions unauthorized distribution, and strong encryption, so that digital rights management really works. So here's one way in which price discrimination in that environment could be effected, is many different versions of an individual recording are distributed, and they are tied to particular types of machine. So that if you want a recording that you can play on your iPod, you pay 25 cents for it. If you want a recording you can play on a $1,000 home stereo, you pay $2. If you want it to play on a $5,000 home stereo, you pay $10. It's the same device, the same file. It's just coded differently for the different machines, recognizing that the ability and willingness to pay of the possessors of the playback devices vary, roughly speaking, with the price of the player. That's one way of doing it. It wouldn't be hard.
On the hardware.
Yeah, tied to the hardware.
Device.
Another example is that, as we now know, the internet is zonable. It's certainly zonable geographically, country by country, and increasingly it's zonable within countries. It's known where your IP address is. Okay, so if you have IP addresses that can localize you, then all you need to do that is tie it to zip codes. And you know what the income distributions are in different zip codes. So if you live in Westchester County, you're just going to pay more than if you live in Mississippi. All right, those are the easy ways of achieving price discrimination. Then there are more sort of conspiracy theory ones that are not out of the zone here, which is, how many people here have frequent purchaser cards at grocery stores? Yeah, okay. So why do the grocery stores use these things? Well, it's a puzzle. It's because they're collecting information about you and what you're purchasing. And very soon, unless and until we adopt privacy policies in the United States, approximately those of Europe, which we don't currently have, that information is going to be dovetailed with all other sorts of information about your purchasing power. So you go to iTunes, you have an identity on iTunes. It's just forbearance that iTunes charges you, everybody, $1 right now. They could tie your identity with what they know about you from other contexts.
What kind of olive oil I buy.
Yeah, exactly. So you bought a lobster last night, it's $1.50 today. Amazon did this for a while and met enough resistance that they backed away from it. But the technology has existed for a bit, and we've already come to accept price discrimination in lots of other contexts. Everybody gets on an airplane and knows that they're paying radically different prices for the other people who are sitting in identical seats. It's not so far away that we'd see that in the entertainment industry as well.
Oh, God.
Just a second ago, you touched on something about privacy laws and how our laws, or the absence of them, differs from the situation in Europe. I was listening just yesterday to a little editorial piece on NPR where the person was saying, it's over, give it up, we have no privacy, we're not getting it back. Can you imagine any circumstances under which this country would institute a set of laws that are anything like the laws that are prevalent in some of the countries in Europe, where to create a database with personal information about individuals, you have to get permission and so on? Or is it over?
Yeah, this is definitely in my specialty, but for what it's worth, my sense is in the current political climate, no. Because we have, for a long cultural tradition of less interest in privacy than is true of old Europe, anyway. And it's just been reinforced in the last 3 years with anxieties about terrorism. And so, in the convergence of those two cultural streams suggests to me the answer is no. Now, private deals may slow the interlocking of information networks. The consumers may insist that particular firms that they're going to interact with guarantee them, as a matter of contract, that they won't make their information available to third parties, and those policies will be enforceable if they are breached, unless the business goes bankrupt, in which case that material becomes available as in a compulsory fashion as an asset. But it's possible that, to repeat, private transaction between privacy-interested consumers and firms that cater to that desire may slow the spread of information. But your question was different. It was, would we see governmental prohibitions upon the sharing of personal data in the United States? And that seems to me, for better or worse, unlikely.
I'm really, I don't know if I'm scared or intrigued by your third alternative, but one part of copyright is, yes, compensation, but the other part of copyright is also control. And I was wondering if you could talk a little bit about how you could maintain a copyright holder's interest in controlling the content in sort of the third alternative scheme, because what you effectively do is you completely take the control away from the copyright holder. So how and then could you compensate for that loss?
So there is a way you could do it either in an alternative compensation system, a government-run one, or a voluntary co-op. They have the same structure on this issue. And the idea is not mine, actually. It was Jamie Boyle suggested this to me. You could offer registrants an option, 2 paths. Option 1 is you submit your work to the registration authority with the understanding that either the public at large or the subscribers are free not just to consume it as it was intended, but to manipulate it however they see fit. Strictly speaking, in copyright terms, you license the right to prepare derivative works. And if you check that box, then you get the benefit of a particular distribution formula. Or you can check the second box, in which you give up your right to control reproduction and distribution, but not the preparation of derivative works. You retain that entitlement, and in the European system, you retain your moral rights, your right to integrity. And then you get compensated, but at a lower rate. So you capture the difference between the artists who place a high value on integrity and those who place a low value by adjusting the payout between the two. Now, depending on what the gap is between those two, artists who value in the integrity of their works may not be fully satisfied because they may feel pressured by the monetary difference, but it's a way of compromising on this front.
I think it may be time to bring our first day to a close with special thanks to Terry Fisher. I think one bright spot is that we've implemented an alternative transportation system to get us to the reception. Which buses leave downstairs? Leaving soon. Should we 10 minutes, say, and other people can walk, and maybe we'll get there for 6:30. Thanks again. Tomorrow we start at 8:30 in the morning.